सामने.
Please, Lordship. Lordship, I beg to mention item number 8. Lordship,
You're for?
respondent number 124, District Council.
Petitioner, Lordship.
Yes. Any objection?
Mr. Dingdo seems he's not well, so that's why.
He's on sanction leave.
Okay. On pre-made on behalf of Mr. T.T. Dingdo, Leonard Senior Counsel, appearing for the respondents. KHDC. Pre-made for adjournment. No? Receive not being objected to by the petitioner. Matters adjourned. List the same after
2 weeks, ma'am.
2 weeks.
Obliged.
Obliged.
Well, number 7 has bring some accommodation. Maybe a shorter date, Your Lordship. Well, next weekend sometime.
You're for?
I'm the respondent
Respondent.
and the petition.
Dr. N. Muziga, Leonard Senior Counsel, appearing for the state respondent, has sought for accommodation on grounds of personal difficulty. The same not being objected to by the petitioner. Matters adjourned. List this matter after 1 week.
Deeply.
My lord, I beg to mention item number 4, my lord. I'm praying for 4 weeks, my lord. Miss Paul is on bereavement, my lord, so it will take some time, my lord. So I'm praying for 4 weeks' time, my lord.
No objection, Your Lordship.
Prayer for adjournment is made on behalf of Miss Paul, Leonard Senior Counsel, appearing for the petitioner on the ground of the said Senior Counsel being in bereavement. The matter not be objected to by the respondent, the prayer not be objected to by the respondent, seems allowed. As prayed for, as agreed to by the parties, this is matter after 4 weeks.
Daily list item number 1.
May it please Your Lordship. Your Lordship, in this matter, we are yet to receive our brief. We have not received our brief. So, Your Lordship, we are praying for some time.
My lord,
You are not giving them copy.
my lord, I have served the copy to the state.
We have not received our
In
brief.
fact, before filing, we are supposed to serve the copy. Then the registry accepts the.
It has to be in the office, Your Lordship,
have
but
to
we
check.
have not received it.
You check on it.
Yes,
We'll
Lordship.
take it at the end of the board.
Yes.
Your Honor, Your Lordship, this matter will be taken at the end of the board.
Item number 3.
No lawyer. End of the board.
Item number 5.
Lordship, I am appearing for the petition appellant. Now, what has happened, Lordship? A paper book was served to me, but few pages are missing. So may I be provide? I told the government advocate he's supposed to provide me with some. So a date may be fixed.
You are the appellant.
I'm the appellant.
You're supposed to file the paperwork.
No, we were given a paper book by the government.
How can that be?
With the
Lordship,
records.
actually, when Sir Mahanta was appearing in this case, he already prepared the paper book and he has served us the copy of the paper
So
book.
2 pages are missing. So I just checked the records. I'll just take the paper book. A date may be fixed, a short date, a very short date, Lordship.
Lordship, moreover, in this case, Lordship, the co-claimant, Lordship, I can draw Lordship attention to the judgment and order passed by the lower court. The co-claimant has already filed an execution, Lordship, in this case.
And what co-claimant? Who is the co-claimant?
Who's the co-claimant?
Lordship, claimant is the brother, Lordship.
Brother has nothing.
The property is almost, it is divided, Lordship.
Is it about property?
Yes, Lordship, it is the land acquired property, Lordship, under for National Highway. So the land which, my contention is that the land which has been, the award, they have disputed the award and they came for reference. And now in the same property, like the brother has filed for execution, simultaneously here the other party in this case has come for before this honorable court. We did not release because we did not release that amount.
In a land acquisition proceeding, can there be execution?
Lordship, it so happened, Lordship, because since this case was pending, Lordship, we were under impression that both of them has come together before this honorable court. So we did not release the lower court money.
Who are you?
I am National Highway Authority of India.
Oh, you're a National Highway. That is, as far as you're concerned,
Lordship.
you are just the custodian of the money.
Lordship.
Eventually, whoever it is to be paid to, you'll do that.
Lordship, we have released the amount to the collector.
We'll have to look at who are the actual parties in contention.
Lordship.
The appellant most probably has come, perhaps of the, I have not read the file, perhaps of the inadequacy of the, of the award. If that is the case, is that the case?
Lordship?
What is the case of the appellant?
Insufficient amount, disparity of in the claim amount given to others.
Exactly. So that is the case. Now, you have come in. Is there a dispute between the claimants?
No, I have no dispute.
Lordship, I'm appearing for the other brother whom he has filed an execution. It's a totally different matter, different sets of matter. He is not aggrieved by the orders passed by the special judicial officer. Now, because compensation has not been paid to him as per the judgment passed by the High Court, that is why he is filing.
And he is not even a party in these proceedings, right? He is not even a party in his proceeding.
Lordship, actually what happened, it is Rajkumar Devra and Sabita Devra. They are two, this case, has, according to the judgment, Lordship, the page 26, Lordship, page 26.
Is what?
Yes.
Of the judgment?
This is the judgment.
Yes, Lordship. So in the judgment, it is the first part is Rajkumar Devra, the second part is Sabita Devra, Lordship. So, Lordship, what happened for us when we are the beneficiary of the land and we are releasing the amount? This has created really a dispute for us also, because when this case is pending before this honorable court, we were under impression that they have already come before this, since they are Sabita Devra and Rajkumar Devra, they are the brothers and sisters, I believe, or mother and son, something like that. So they are from the same family, Lordship.
Excuse me.
So?
They are from the same family, Lordship. So we were under impression that since this case is pending, Lordship, we have not released the amount in the lower court, Lordship. Because, and moreover, when the execution has come up in the lower court, and simultaneously these cases also pending before this Honorable High Court.
Ms. Bhattacharjee, what you can do,
Lordship.
you should approach the lower court for stay of the execution proceeding.
Lordship.
And if there's, if the matter is at all related to the impugned judgment order here, then you see that you have to work it out and see in what way you can either make the necessary the other claimant necessary party, or whatever, in whatever way you think fit. But now, as has been submitted, he is not even a party here. No. The execution that you speaks of is not in question.
Lordship.
So what can this court do?
Lordship.
At the most, you take recourse.
Lordship.
And if necessary, you file an application for stay. That'll be for you, or for the aggrieved party, whoever is he or her.
Lordship.
Lordship, can the matter be fixed on the 19th of March if it's not inconvenient for hearing?
No.
19th of March?
Lordship, not on Wednesday, because Lordship, the Nongpo, all the LA matters are fixed on Wednesday only.
Then 21st of March?
Lordship.
Not on
20th?
20th.
20th of March?
Not on 21st, because
20th of March, Lordship.
Learner counsel for the petitioner, or for the appellant, who has sought for accommodation.
When am I going to do it?
On the ground that the paper book already filed with this court requires some correction, which requires some correction, for which permission is sought for from this court for correction of the same, and to be filed, and a complete set to be filed within the next date fix. On premium, the same is allowed. As agreed to by the parties, list this matter on 20th March.
Item number 6.
My lord, this matter also, we are assailing the order passed by the special court in acquisition matter. But what happened, we agree, the collector has passed a award at the rate of 80 rupees per square feet. And when the matter went to special court had enhanced to 800 per square feet, more than 10 times of the amount fixed by the collector. So we agree with that. Another issue is, my lord, the date for determination of the market value is from the date of the Section 4 notification. Section 4 notification. But whereas the reference court has taken different date. So though the case is lengthy, but the issue is very, very limited. So I'll try to shorten my submission also, and comes to the crux of the matter. Now, I'll just go to the operative portion of the judgment, so that before I take to some of the relevant annexure.
How long will it take, Mr.?
Well, it will take half an hour, 1 hour maximum, will subject to lordship permission.
You know very well the constraint of this court. As far as what we can do,
Yes.
if you agree, we'll take it up in the second half.
I'm ready.
Whatever is convenient for your lordship.
Subject to lordship convenience, otherwise all of us are here. I don't know my friend.
For me, it's okay, my lord. No problem.
So we'll take it up in the second half.
Item number 9.
Lordship, 9 and 10 are connected matters. Lordship will recollect this is that court has granted an interim anticipatory appeal, and there was some serious allegation against the IO demand. So Lordship, we just received it's a bit bulky instruction in the morning itself. Lordship, just seeking accommodation if this matter can come up either this Friday or maybe Monday, subject to my friend's convenience. We just received today morning, Lordship, the case diary and they are still under interim, so Lordship, that should not be a problem.
Oh. Mr. Kikhan and the PP
Okay, Monday
has submitted that the necessary papers have been received from the IO. However, since the same has not yet been produced, some time is paid for as far as this matter is concerned.
Monday get it.
Days third. So we'll take it up on
Third.
On today's third.
We'll take it up on Monday, Lordship, third.
Why Monday? We'll take it up on Thursday. I think that can give us.
No, sure.
You're talking about the CD, isn't it?
CD and the status, yes.
How long will that?
Same.
Premier parties list this matter on 27.
Okay. Will be there, no? 27.
So interim order is until further
In the
order.
meantime-
It's until further orders, Your Lordship, so that
In the meantime, as prayed for, the interim order will be enforced till further orders. So that is for
10 also same, Your Lordship, 9, 10.
9 and 10.
10.
Same order.
Item number 11.
Just a moment. Just call Mr. Sangresu. Mr. Sangresu, looking at the time, if the other matter could be, finished. Yeah, and if time permits, we can start.
Yes.
Then we can continue.
My lord. Other division bench rise up.
I mean, if it's convenient to you.
Yes. But I'll inform to my friend also.
Yeah, you just inform him.
I'll
in
inform
case,
him.
because then
Yes,
if second half might
Right.
take some more time, or I don't know.
Right.
Otherwise, still this code rises for the DB.
Well,
We'll take it up.
Only 11 and 12 are the NDPS bails, my lord. But may I pray for Thursday, my lord, because I could not get all the papers, my lord.
What is the stage of the case?
Charges has not yet been framed, Your Lordship. Last date, Your Lordship was pleased to observe on the previous date also, on the last order, that this bail is only on the ground of delay in trial.
Or delay in trial?
Yes, Your Lordship.
Yes.
Till Thursday, my lord. I'll have it somewhere.
Thursday.
The other matters are also coming on Thursday, my lord.
Let it come tomorrow or day after, Your Lordship, on Thursday.
Because being holiday, I couldn't get all the some details, my lord. It was a long weekend.
On Wednesday, let it come, Your Lordship.
Thursday.
Not on Thursday, because Thursday this case is there, so I have to go there.
It's fixed on Thursday.
27, yes.
27.
27.
We'll take it up on Monday then.
Monday.
See, what happens is, if you go, and then you know the progress of the case. You know what is the stage of the case.
Yes.
How many, witnesses have been examined or will be examined or whatever. Then you come and report before this court.
Charges is to be framed.
Oh, charges is to be
Yeah.
framed.
No witness, single witness has been examined yet.
Okay.
So on Wednesday, if Lordship.
And when was the charge sheet filed?
Charge sheet was filed November 2023.
Oh.
In the month of November 2023.
Why charges have not yet been framed? To Mozika?
Because what happened, my lord, because we don't have any counsel, this is without instruction, my lord. Mr.
Mahmood.
Mr.
He was regular counsel was there, Your Lordship. I am aware of the case. Regular counsel was there. the case was, argument was done, but the learned trial court took 6 months to pass the order on that framing of charge. And your lordship, then we kept on requesting then. So I don't want to because
which court?
District Judge Nongpo. So all these things I am not.
NDPS matter.
Yes, sir.
Well, moreover, what happened? Well, the public prosecutor, Mr. Mabul,
He did not take time because subsequently another counsel, your counsel, regular counsel was there, but he also took time for argument and all these things. That was delay was there. Some delay was there also from the prosecution.
So but on Thursday, the matter is posted for framing of charge.
That has no direct bearing on bail, my lord. Even if charges are framed,
Yeah,
Section 37 involved?
Section 37, your lordship, yes. But this is commercial quantity, but since these accused persons are behind the bar for 1 year and 9 months, no progress is there in the trial, and there is no prospect in the future also that trial will conclude soon. So on that ground, sole ground, your lordship, I have preferred, and I have enclosed the judgment also of the Honorable Supreme Court, where even in this type of cases, your lordship, 1 year, 4 months also bail has been granted. So I am also praying on parity, your lordship, because Article 21, your lordship, has also passed previous judgments and orders.
You have to look at the facts, circumstances,
Facts
and
circumstances.
to what extent the petitioner is involved.
Petitioner's involvement, your lordship, on the ground that their contact CDR only on the basis of statement made under Section 67. This your lordship has already observed while rejecting this is the 4th bail application. Your lordship has observed that one also, and that's why I am not taking on that ground. Only on this ground, your lordship. How long they will be inside, your lordship, it will be just a punishment for them. And
my lord has rejected the bail after a detailed hearing in the month of
yes,
May, my lord.
May last year.
So the only ground available to them is,
yes,
if at all, my lord, is delay. Apart from
that point of time,
on merit, it has been rejected by your lordship.
Even your lordship has rejected the bill in the month of May 2023.
24.
Since 24, and thereafter, your lordship, at that stage also the charges was not framed. Even till now, the same stage is there. So much, your lordship. Then let it come on Wednesday, your lordship, if your lordship. Otherwise, no problem, your lordship, because they are inside. So
we'll take it on Monday.
All right.
On preliminary parties, this is matter on Monday. So I can
11, 12 both.
Second call, item number 1.
May it please your lordship. Your lordship, this instant bail application is being preferred by the petitioner under section 483 of the BNSS for enlargement of regular bail, my lord. My lord, the petitioner is in custody for more than 2 years. The charge sheet has been filed before the learned trial court. Charges has been framed, my lord. There are 32 witnesses, my lord. 4 witnesses, one is the victim, has been examined, the complainant has been examined, the independent witnesses are also examined, my lord, and the rest are only the government, the rest 29 witnesses are only the government official witnesses, my lord, which cannot be hampered and tampered anyway, my lord, during the trial. So, my lord, I only pray to issue notice to respondent number 3 because this is a POCSO matter, my lord. Respondent number 3 is the complainant, my lord. At this stage, my lord, to issue notice to respondent number 3.
Mr. Khan, there's a POCSO case. Why so many witnesses? Official witnesses, 29? What would you need them for?
Actually, three accused person is a kind of a gang rape, and we also surprising why 32? Why 32?
See, what you would need at the most is the medical evidence.
Medical? 164
Yes,
statement of the victim?
Examine the survivor, so on and so forth.
Maximum 5, 6, at the best 5 or maybe 7, 8. I also was surprised at this case, 32 witnesses. So at this stage, Lordship, let notice we go. We'll see what happens when the notice comes, because actually submitted 32 witnesses, 4 has been examined, and then it's more than 2 years. She comes within the meaning of 35 at least. She's making up a case of 35.
No. Once the trial is in progress, issue of 35 doesn't come.
Very true.
Issue of 35 means only if the court has not taken any steps.
Any steps,
Sorry,
yes, yes.
If the proceedings has not progressed, substantially, then.
And Lordship, in the meantime, when the notice issued, let her also just satisfy or maybe bring on record. When was the last stage of all the witnesses? It will be easy for us.
When was the last date fixed?
And when is the next
The
date?
last date was fixed on the 27th last month, my lord. And PW4 has been examined. Yes, my lord.
And when is the next date?
The next date is on 6th of March, my lord. Yes, my lord.
So those are important factors. In the meantime, let notice go, Your Lordship, till the 3, no? 2 or 3? 3.
Heard this. Counsel for the petitioner was submitted that this is an application for grant of bail on behalf of the petitioner in connection with, what is the case number?
My lord, case number, it's Dingpaso Police Station, my lord. Case number 01 subclause 3 of 2023.
Now it's evidence stage, so we're talking about the case before the trial court.
Trial court, my lord.
Special POCSO case number 24 of 2023 before the Learned Special Judge POCSO at
East Khasi District, my lord, Shillong.
East Khasi?
Yes, my lord.
At Shillong. However, at the outset, the Learned Counsel has submitted that notice may be allowed to be issued on the respondent number 3, the respondent number 1 and 2 has since been represented by Mr. K. Khan, PP. On submission made, let notice be issued on the respondent 3, the same, returnable within 2 weeks. This is the matter thereafter.
Highly obliged, my lord.
Satisfied? Next date? What is the next stage?
Yes. Item number 2.
Lordship, on previous, I think my friend, she is appearing, Sanchita.
I'm appearing for the seat. On the last occasion, status report had been called for. It is before my notes.
Yes,
my lord, we come to.
Yeah, just who's appearing for the state?
State, Sanchita is appearing. I am for the petitioner.
You are for the state?
I'm for the state.
I thought you are for the petitioner. Have you filed your status report?
Yes, ma'am. If my lord may come to para 4, on 27th August 2024, a court order was received where the accused had applied for the grant of anticipatory bail, wherein he was given interim bail on the condition that he should appear before the IO as and when required, and that he shall not abscond or tamper with the evidence and witnesses. Thereafter completion of all formalities, he was allowed to go. His interim bail was made absolute by the Honorable High Court with conditions that firstly, he should appear before the IO if and when required. Secondly, he should not leave the jurisdiction of India, etc. On the 22nd September 2024, the original document, that is deed of agreement between so-and-so and so-and-so, was produced by the counsel representing the accused, Shri Gopal Krishna Gaur, and accordingly the same was seized. Para 5, prayer was sent addressing to the CJ in West Garo Hills for recording of specimen handwriting of the complainant, witnesses, and the accused. The prayer was accepted and the same was fixed on 14th November 2024. A WT message was flashed addressed to Vidyadhar Nagar Police Station, Rajasthan, to inform the accused to appear and produce the original documents at Carmel Police Station. The reply was spoken to the Superintendent of Police Tura was received, in which includes all the related documents and notices, etc. Upon analyzing the documents, a total around 7 crores was due. Notice under section 91 CRPC was sent addressed to the accused through WhatsApp of the accused in speed post to appear on 14th November 2024 and to produce the original passport as per the Honorable High Court's order. The notary attested copies of NOC, agreement deed, GPA, revocation, GPA, deed of agreement, receipt of original passport, deposit in Jaipur Passport Office, deed of agreement of new appointee, and bail order was received through speed post, but the accused had not personally appeared. On 14th November 2024, the specimen handwriting of the witnesses were recorded under the presence of the Honorable Court, and as the accused didn't appear, the same was refixed for 17th January 2025 for recording the same. Notice under Section 41A was being sent via WhatsApp and speed post to appear at police station on 10th December for investigation purpose, but he didn't appear for the same, giving excuse of lower backing. A notice under Section 91 was sent for providing the certified copies in respect of taxes pending, etc. The certified copies of the same reveal total of around 8 crores. Further during investigation, the PAN card and Aadhaar card of the accused was found, and accordingly a notice under Section 91 was sent addressing the IT department to provide the account details. Advocate Vijay Kumar Mahajan of Rajasthan appeared and produced the original document in connection with Gloria bonded, and accordingly the same was seized. He further produced the medical certificate of accused stating that the accused is suffering from LD and lower backache and that he could not appear personally. Accordingly, a notice under Section 41A CRPC was served to the advocate, which he agreed to do on behalf of the accused and to make him appear within 15 days and to appear on 17th January 2024 for recording of specimen handwriting, but he did appear for the same. A notice under Section 91 was served addressing to so-and-so. Further during investigation, multiple phone numbers and bank accounts were found, but the analyzing of the same is not yet completed due to huge size of data. Now, my lord, we come to Para 13. During the course of investigation, various clues were found and the accused was required to appear before the IO for investigation and to ascertain more facts. But despite of serving various notices, he failed to appear before the IO, giving medical excuses via speed post, and that his phone was also kept unreachable. That he was even required for recording the specimen handwriting at the Honorable Court of CGM Tura on 17th January 2025. Despite several notices served to him, he failed to appear, keeping the case pending due to non-cooperation of the accused. On the 16th February 2025, information was received that the accused and his son were at Khanapara police station, and as they were wanted in connection with Tura woman police station case number so-and-so, they were apprehended and brought at Tura for investigation purpose. It may be noted that this case was registered as the son of the accused, Shri Rahul Sharma, had threatened one of the witnesses, Shri Kishore Kumar, and his family over WhatsApp call. On 17th February 2025, the accused Shri Gopal Krishna Gaur was arrested in connection with Ampati police station case number so-and-so. The case is still pending for various replies, that is PAN card details, transaction details, and the recording of specimen handwriting, and further interrogation of the accused person is required. But due to his non-cooperation, the same is kept pending. That the accused is not a citizen of Meghalaya, and despite sending several notices to the accused, he has not complied or appeared before the IO or the court of CGM Tura for recording of specimen handwriting and statement in a 161 CRPC. Those are the cases still pending.
So now that's the status.
Please.
Now what about the maintainability of this petition now?
Lordship, previously also I drew Lordship attention to the Gujarat High Court, which I have already provided Lordship the judgment. Lordship, I the judgment.
Yes. Para?
Just a minute, Lordship. I'll just find out from my document. Lordship, the judgment is in page 17.
Page 17?
Page 17, para B, para B, whether it is
Para?
permitting the
Para
case.
B?
Lordship, then.
You're referring to what? To the judgment?
Lordship, yes, Lordship. The judgment is Ashok Godharam, Lordship. Lordship is referring to that.
Yes, I have the judgment. Now you
Ashok
you refer to
Godharam.
the relevant para. What is the relevant para?
The relevant para is in page 17. The question is whether it is subpara of B. Para 23 B.
So that's what you should say. You went directly to subpara 3. What B? What
23. Para 23. Para 23.
Yes.
Para 23, then B. The question is whether it is permitting in the case of cancellation of bail of anticipatory complainant has the locus standi to point out incorrectness in the order of granting anticipatory bail. It is true, may I, Lordship? It is true that in the case of cancellation of anticipatory bail, the victim has the right to file application for cancellation of anticipatory bail before the Honorable Supreme Court. It may be in the High Court also, Lordship. It is reflected because this judgment, it may be in the High Court also, Lordship. So victim here, I am the, in the entire scenario, I am also the victim, Lordship. So I have the right to file cancellation of bail, Lordship.
How are you the victim? In what way you are a victim?
Lordship, the misappropriation of the entire the transaction of misappropriation of money has he has planned it starting from this bond, Gloria bond, which has subsequently affected all the bonded warehouse, Lordship. So I am being one of the owner of one of the bonded warehouse. I also got victimized in the entire plot planned by him, Lordship. Subsequently, one more judgment also, Lordship. Lordship, in Ranjit Singh versus Nandlal, in Ranjit Singh versus Nandlal,
what is that? Have you filed?
para 5. Pardon.
I don't have that judgment. Para?
Para 5. Para 5. Then it is the next page, Lordship, page number 3. After para 5, the next page, Lord. Then the subpara is 1, 2, 3. It starts from High Court or the Court of Session, Lordship.
Yes.
Lordship, a High Court or the Court of Session may direct that any person who has been released on bail under this chapter be arrested and commit him to custody. Subsection 2 of Section 439 CRPC does not state that the state government alone can make an application for cancellation of bail. The court can suo motu issue notice to cancel the bail if it comes to its notice that the session judge granted bail to the accused on onerous or some extra grounds. There is no prohibition in 439(2) criminal procedure that an application for cancellation bail cannot be made by a private person, Lordship.
Yes.
Furthermore, Lordship, if I the 1, 2, 3, 4, 5, 6, 7, 8, ninth line, Lordship, from a private person, ninth line, Lordship. It is not necessary, Lordship, may I?
Yes, ma'am.
It is not necessary that the may I, Lordship? Ninth line, on the ninth line, Lordship. Session on inodorous ground. Then it starts. It is not necessary that the High Court should be.
I'm trying to find out.
Okay, ninth line, 1, 2, 3, 4, 5, 6, 7, 8, 9. On the ninth line, Lordship.
Nine from below.
No, from below 1, 2, 3, 4, 5, 6, 7, 8 line. 1, 2, 3,
Yes.
4, 5. It is not necessary.
Yes.
It is not necessary that the High Court should be moved only by way of revision petition under Section 401 Criminal Procedure against the order granting bail. It can act in this behalf suo motu or an application moved by the state or even by a private complainant, Lordship.
Yes.
Lordship, these two judgment, Lordship, has here in both these two judgment has granted that the power to file a cancellation of bail by any private party who can who is a victim of entire process. I am being victimized, Lordship, because the entire action of his it all started from what I have previously mentioned, that it all started from this bonded house, and later the conclusion ended up in Suchona bonded warehouse, which where I am the proprietor of that Suchona bonded warehouse.
But have you filed any complaint on your own?
Lordship, my FIR is already lodged, but Lordship, the entire process, Lordship, has it is his malified intention to around what we have counted, Lordship, and there are taxes. There are a lot of taxes, Lordship.
Now, what I can understand is this,
Lordship.
This case pertains to a particular bonded warehouse, Gloria bonded warehouse.
Lordship.
And that person has filed the FIR.
Lordship.
The matter, has proceeded, and the accused had come before this court, and interim bail was granted.
Lordship.
So investigation is going on as far as that complaint is concerned.
Lordship.
Now, in the meantime, you say that you are also affected by the action of the accused.
Accused, yes, Lordship.
Or petitioner. Now, what happened is you have filed a separate FIR.
Lordship.
Investigation is going on.
Lordship.
Whether he has been arrested as far as your complaint is concerned or not, that is not before this court.
Lordship.
Now, if I understand correctly, you say that whatever has transpired, or rather whatever the accused has done, as far as that Gloria bonded warehouse is concerned, is also connected to you.
Lordship.
Because there's a series of action which he has done.
Lordship.
Don't you think that as far as your complaint is concerned, that aspect of the matter will be looked into by the IO? See, it will be looked after by the IO, and he will file his report to implicate the accused in as far as your complaint is concerned.
Lordship.
But here, you see, here it speaks of private complainant, no doubt. But private complainant means the complainant who has filed the FIR.
Yes.
Not a person who has just come
Third party.
out of nowhere.
Lordship,
I don't think, see, in all fairness, I don't think it's proper for you to, to come before this court with this application. Number one. As far as the prosecution is concerned, if the IO, feels that there is a violation of the condition laid down by this court, then it is incumbent upon the prosecution to file an application under relevant provision of law for cancellation of bail. On that ground, only on the ground of violation of condition, the court can look. But the court cannot interfere with the, with the progress of investigation at this point. You have your remedy, no doubt, as far as your own case is concerned, but you cannot just intervene in any prosecution or in any case where the accused is involved. This case will not help you. Either you withdraw this petition or I'll pass this to orders.
Lordship, regarding there is one more judgment, Lordship, where it is said that the third party also can, the party who is victimized because of the action of the
how will you prove that? You see, you have to prove there must be some prima facie evidence that you are also victimized as far as the action of the accused is concerned with regard to that Gloria bonded warehouse. If you can prove that there is a link, perhaps. Even so, you see, that has to come from the IO. And now you are stating that you have your own case. You have filed your own complaint. The law, you see, the law has been set in motion as far as that matter is concerned. Why would you come and interfere in somebody else's case? Yes, tell me.
Lordship, I'll seek instruction from my client with regard to this, Lordship.
Please. On pre-made by the parties, this is matter tomorrow. So tomorrow?
Tomorrow, Lordship.
Item number 3.
Good morning, Lodge.
Yes.
Your Lordship, I filed a criminal misapplication. In continuation of a bail which was given to the accused.
Excuse me.
Sorry, Your Lordship.
Excuse me. I'm having the...
Right. May I?
Yes, please.
Okay. Your Lordship, in the month of... sometime in last year, Your Lordship, in bail application number 32 of 24, Your Lordship had granted interim bail to the accused person. His bail application has been preferred on behalf of his bail application was preferred on behalf of his mother. Now, taking account of his health condition, Your Honor had granted him 2 months of interim bail. Thereafter, pursuant to his release, he got himself checked, and it was advised by the doctor that he needs to visit CMC Vellore. And on the cusp of the expiration of the interim bail period, I had filed a criminal misapplication seeking for extension of the interim bail. Your Lordship, which is at Annexure 1. I'll take you to Annexure 1, which is at page 17. Sorry, which is at page 15. Now, why this particular order, Your Lordship? You were pleased to grant him another 3 months of interim bail to get himself treated again at CMC Vellore. Now, what happened pursuant to that, Your Honor? I'll take Your Honor's attention to those particular aspects. I'll take you to Annexure 2, Your Lordship. And I must remind the court, Your Lordship, that basically this benefit was given to him so that he could get himself treated for ulcerative colitis. I believe Your Honor's remembers. So, Annexure 2.
What is this?
So, this is a status report of the reimbursements which would be made by the DHS. I'll take you to page 19. And I believe in the last column, Your Lordship, you will see that the reimbursement...
You should have given a clear copy of this.
I understand, Your Lordship, but this is the only thing we got from there. And we tried our best, we tried a level best to do it again.
You could have, you see, this you could have got it retyped.
I understand.
File a clear copy.
No, because this, Your Lordship, we couldn't get it from the internet. This was given to us by DHS. We tried again and again and again.
Exactly.
Right.
When it was given to you,
right, Your Lordship.
Immediately you retyped the whole thing.
All right, all right. I'll keep that in mind.
Get a clear copy.
I should have typed it. So I'll take you to... Anyways, I'm sorry for that, Your Lordship. I'll take you to page 18 again. sorry, I forgot to take one aspect. As you can see, sir, from the heading, which is file number, Your Honor would be able to see that it is with regards to the accused Daniel CM.
Okay.
Right, and I'll take you to page number 19. And the last column at the very end of the page says that it is in process. Now, what is in process, Your Lordship, is the disbursement of the funds which would allow him to go to CMC Vellore for treatment.
Okay.
Now, what happened during the interim bail period also, Your Lordship, the order which you had passed extending the accused person's bail, it was passed on the 26th of November 2024. After his release, he again visited the attending doctor at civil hospital. And I'll take you to Annexure 3, Your Lordship. This is post his release. Annexure 3, page 20, post his release. As you can see from the date, Your Lordship, it is the 29th of November 2024. Thereafter, Annexure 4, page 21, it is on the 14th of December. These are all pursuant to his release after the interim release. Thereafter, again, Your Lordship, Annexure 5, 4th of January. What I'm trying to imply, what I'm trying to tell the court is that his condition is still the same, remains to be the same. And in fact, Your Lordship, if I may be allowed to take you to Annexure 6, this is not a medical report, but this is...
So you mean to say,
yes, Your Lordship.
Since the last order of this court,
absolutely,
he has yet to be, to go to Vellore.
Absolutely.
He has not yet gone.
Not yet gone.
The reason being of the
non-disbursement.
Non-disbursement of the required funds.
Absolutely.
By the DHS.
Absolutely. But my endeavor is also to take Your Honor's attention to the fact that his condition is actually not improving. Because when I've made the prayer also for regularization.
So what have you done in the meantime?
Absolutely.
He has not been treated anywhere in Shillong?
No, that is what I'm getting to. Because if I can recall from the last, although it's not reflected in the order, Your Honor had verbally advised me to also look for other treatments, other hospitals, go to other hospitals. So we also took him to Negrams. We took the accused to Negrams. When I say we, sir, I mean the accused person's family. And I'll take you to page 25, which is Annexure 7. Now, okay, he was being treated in civil hospital before his release, and post his release also he went there. But as for a second opinion, the accused was taken to Negrams. Are we at page 25, Your Lordship? Page 25, Annexure 7. Now, this is from Negrams. So he was taken to Negrams on the 16th of January 2025. So the first page contains basically the medicines which were prescribed to him and the other things, and the BP monitors, etc., the BP levels, etc. Now, page 26, which is also from Negrams, says the same thing, absolutely the same thing. Let me take Your Honor's attention to the last paragraph. Let me remind you, Your Lordship, that this is from Negrams, page 26, Annexure 8.
Yes.
Negrams, dated 21 January 2025. The patient is symptomatic despite treatment and is referred to gastrologist CMC Vellore for further management. So for a second opinion, we also went to Negrams. Negrams advised the same thing, go to Vellore. Civil is also advising the same thing, go to Vellore. And like I took Your Honor's attention to the status report, it is still in process.
Mr. Yadav.
Yes, Your Lordship.
I can understand your point.
Right, Your Lordship.
The accused person have got the benefit of this court's order.
Absolutely.
For treatment. He was initially advised to be treated at CMC Vellore, but as you have said it, that the process for disbursement of the funds and all that has not yet completed.
Yes, sir.
In the meantime, you had gone to Negrams. Negrams has also advised him to go to Vellore. That would be your contention. That would be your lookout.
Absolutely.
As far as this court is concerned, it will not go into those details.
I understand.
But I would accept your assumption. Yes, he is still in need of treatment, and he should.
Now, so my endeavor is also to impress the court the fact that he needs to be outside and not in custody. And why do I say so? Is also because of Annexure 5,
Yes,
Because let me
yes,
just
tell me.
complete. I'll tell
Yes, you,
Lordship, there are more things. If I could just give me 5 minutes, I'll complete everything because he also suffers from major depressive disorder. I'll take your Honor's attention to that. I'll just take 5 minutes to finish everything, if you can, Your Lordship.
Yes.
Let me take you to Annexure 5.
What is Annexure 5?
Annexure 5 is an outpatient record from Civil Hospital Shillong. Annexure 5, page 22.
Yes.
The last very line refer to dietitian for diet.
Where?
The last line, Your Lordship. Annexure 5, page 22. Refer to dietitian for diet.
Yes.
Right? Thereafter, he was taken to Nazareth, where a dietitian has charted out a plan which he must follow in order to ensure that his condition does not further deteriorate. So that is why, sir, that will not be available in custody. That is why also I impress upon the court. That is what I'm trying to pray for as well, that he needs bail. And one more thing, Your Lordship, he also suffers from major depressive disorder. Your Honor had actually asked me to also avail other facilities within the local jurisdiction, if so available. So what was being done is when he was in custody, he was being treated by Civil Hospital Shillong. After the interim bail was granted to him, and after his interim bail was extended, he continued to go there. And Your Lordship, let me also take you to Annexures 8, 9, 10, and 11. And 13. These annexures, I'll just bunch them together. Now, these annexures are post his release. Are post the extension of the interim bail, which was granted to him on the 26th of November 2024. Thereafter, he went to the civil hospital. The attending doctor opined the same thing. The two things which were opined were: number one, Your Lordship, that he needs regular medication with regular follow-up, and second, that the patient needs strong family support. Let me take you to page 34, Your Lordship. Page 34.
Yes.
The second para. Patient needs strong family support as he has suicidal ideation and thoughts. Now, these annexures which are bunched together, Your Lordship, annexures 8 to annexure 13, see the same thing. On every occasion, he went to the psychiatrist. He was advised the same thing. You need constant follow-up, and that you need strong family support. Thereafter, an assessment was done of the accused, which is at page 40, which is at page 35, by the civil hospital.
Yes.
Let us go to the impression. On Beck impression inventory, BD2, must be a technical term, of course. The client attained the score of 51, which is currently indicative of severe depression. Let me take you to Annexure 15 as well. This is the recent, Annexure 15 is the recent psychiatric medical report of the accused from civil hospital. It says the same thing again. Page 37, the relevant portion, Your Lordship. The same thing has been advised, that he needs strong family support. And the last annexure.
Yes.
And the last annexure, Your Lordship, is from MIMHANS. So it is not that we have to go into the same doctor again and again. We also went for a second opinion. Page 38, annexure 4. Annexure 16, Your Lordship, sorry.
Yes.
Now this is from MIMHANS. So he was again tested there. And I'll just read out the opinion if I may. Opinion recommendation. It is of the opinion that the patient is currently suffering from major depressive disorder, and he is required to continue his treatment and come for follow-ups and to prevent further deterioration. As patient is still having depressive symptoms while medications are being optimized, he needs to be in close observation. Family members are advised to watch for any unusual behavior. He should also continue treatment for ulcerative colitis. Now, three things I wanted to impress upon the court, Your Lordship. Firstly, that if we send him to custody, his condition will deteriorate. Why? Because he suffers from number one, major depressive disorder, which will deteriorate if he's inside, because he needs strong family support. Secondly, the dietitian has actually charted out a diet plan for him, which again will not be possible in custody. And of course, three is that he's suffering from ulcerative colitis. And the moment the funds are disbursed, he would be going to the law. In any case, Your Lordship, because he also suffers from major depressive disorder, it would be kind of the court to consider that and regularize his bail, considering his psychological condition as well.
Yes.
Yes, if I may, Your Lordship. Your Lordship, firstly, Your Lordship will appreciate that this is a case of involving drugs of commercial quantity. So now, Your Lordship, the petitioner had moved for interim bail to enable him to go to Vellore. And he had moved a bail application, and Your Lordship was pleased to enlarge the the accused person on bail, void order dated 26/09/2024. Your Lordship had allowed the petitioner for an interim bail of 60 days. Your Lordship had granted it in order to facilitate the accused person to go to Vellore for treatment. So, Lordship, after the period of 60 days had elapsed, the petitioner once again was before Your Lordships, filing for a second bail application. This time asking for extending the same for a period of 3 months. So, Your Lordship, void order dated 26/11/2024 had very kindly allowed for extension of the bail for a further period of 3 months. Now, Your Lordship, in this instant bail application, the petitioner is again before Your Lordships praying for a further extension for a period of 6 months. On the ground, Your Lordship, as Your Lordship has rightly pointed out, that the DHS has not disbursed the financial aid, which is at page 5, para 6 of this instant bail application. If Your Lordship may kindly come, if I may. It is at page 5, Your Lordship. She may kindly.
Yes.
At page 5, para 6, if I may read, Lordship.
Yes.
That thereafter the petitioner checked with the office of the DHS, and it was intimated to her that the disbursement of the financial aid is still in process, and this information was given to her on the 7th of February 2025. That is his stand in this instant bail application. But Your Lordship, in the previous bail application, which was the second bail application, which Your Lordship had granted for a period extension for a period of 3 months, that is the bail order dated 26/11/2024. That order, Your Lordship, is at page 15. If Your Lordship may kindly come to page 15 of this application. Yes. Page 15, para 2. If I may read, Your Lordship.
Yes.
The learned counsel also submits that pursuant to the said order dated 26/09/2024, the petitioner had taken steps to procure necessary funds towards the cost of treatment, etc., for which, as is entitled, she had approached the Director of Health Service for sanction of such funds. However, since the process of sanction had taken some time, the final order of sanction having been made on 19/11/2024, thereafter the accused patient could not proceed for the said medical treatment on time. Now, this point, Your Lordship. Now that the sanction has been accorded, the accused person may be allowed to proceed to the said hospital for the necessary treatments, further submits the learned counsel. So, Your Lordship, this second bail application was granted by Your Lordships, taking into account that the DHS has already disbursed the financial aid, and which is being claimed here at para 2, Your Lordship. And now again, in this instant application, he's taking a U-turn, and he's claiming, Your Lordship, at para 6 of this bill application that has not been disbursed. So, Your Lordship, this the petitioner cannot take such a is taking the court for a ride, Your Lordship. So, and as Your Lordship, so as for the petitioner in this case, he is suffering from ulcerative colitis. This is not a life-threatening disease, Your Lordship. In fact, in Shillong, there are even treatment facilities in civil hospital for cancer. So, Your Lordship, there this treatment, Your Lordship, cannot be cured. It cannot be cured, but it has to be treated through medicine. So, Your Lordship, where is the question of going to Vellore, Your Lordship, where where, Your Lordship, medicines are even available online, it reaches. So, and as for the psychological condition, the psychological which my learned friend has annexed in the petition, Your Lordship, any person who's in fear of going into jail for a period, for a heinous offense, he will definitely have depression. He will definitely have suicidal thoughts, Your Lordship. So, Lordship, if Your Lordship takes that psychological test into consideration, then plenty of nearly almost all of the criminals will have to be let go, because everyone who is in apprehension of being arrested and going into jail will have psychological impact on himself. So that is the thing, Your Lordship. So I have a very strong objection to this, because he's claiming for this bail application on very shaky grounds. Your Lordship has already been very kind with Lordship, and as for the petitioner saying for family that he will be in requirement of family around him protection. Lordship, that is the reason he need not go to Vellore, Your Lordship. For that, adequate facilities available in Shillong itself, and this is a treatment which is not for operation; it is via medicine, Your Lordship. So there's no, I don't see any question. Humble submission.
If I may, so Your Honor's attention to the annexure which I had annexed in the last bill application. Now, therein where I annexed that particular annexure from the DHS department. Now, that particular annexure had said that it is sanctioned. But what do we await? We await disbursement. If you so remember, Your Lordship, it said that yes. So yes, it was sanctioned. Your Honor took note of that fact. Your Honor took cognizance of that fact and said, okay, wait. But we're still awaiting disbursement. Now, secondly, I can reminisce this same exact argument when I submitted the last bail application, the last criminal misapplication, wherein I paid for an extension. Therein, we had the same debate, Your Lordship. When Mr. Ravi Gurung had said that he need not go, everything is being provided for here within the state. He does not need family support. There, Your Lordship had advised me to go to other missionaries, excluding civil hospital, and that is what I did during this period. I went to Negrams, the topmost medical facility within the state. Now, that facility is saying that you need to go to Vellore. And I also went to Mimhans, perhaps the most premier medical institute within the state. That particular institute is also saying that you need family support. And I remember Your Honor telling me on the last occasion, although not within the order, but verbally Your Honor had said, please go to other institutes, and if so, that he does require family support, and if the psychological tests from other institutes say the same, we may consider regularization of the bail as well. And that is what I did during this interim period. Had I just taken a step back and relied only on the medicals from civil hospital, it would have been my fault. But as advised, I went to other institutes as well. And all the other institutes which are within the control of the state government, civil hospital, Negrams, all say, go to Vellore. Mimhan says, you need family support. Civil hospital says, go to a dietitian. Dietitian gives me a chart, which needs to be followed strictly. Considering all this, would it be apt to keep a person behind the bars? Now, he had also said that any person who is convicted or is undergoing trial would suffer from depression. Now, tell me how many people would be advised for family support? How many people of them are actually advised to come for regular checkups? He is. Can we overlook that fact? We cannot overlook that fact. I am here on medical grounds, and it's evident from the annexes which I've annexed that he needs to be outside. One reason, because he needs family support. The other reason, he needs to be in strict diet. The third, that he also needs to get himself operated at a Vellore. And even if you leave the third aspect behind, the Vellore factor. For the other reasons also, he needs to be out, Your Lordship, because if he is inside, again, he wouldn't have family support and he wouldn't be able to be on a strict diet. We have tried all the premier institutes. How is he at fault?
So
yes, he is undergoing trial. Now, the rigors of Section 37 do apply. I'm aware of that. I'll take care of it. When I moved the first bill application, in the last paragraphs, Your Honor noted that there have been technical mistakes made by the investigating agencies. Those are different. I will actually cover them during the course of the trial. But at this particular stage, Can we overlook the medical condition of the accused? And in the prayer, Lordship,
Yes, I've heard about this.
Lordship, there's
Lordship,
one
just
more thing.
a small.
In the prayer, I've actually prayed for regularization of the bail, if so feasible. If so feasible, Your Honor may look into it.
Your Lordship, as my friend has stated that the DHC has not yet been disbursed, the fine. Lordship, that prior to filing of bail, he should have confirmed that, Your Lordship. After he has confirmed everything, then after that he should have come, because even the order is very misleading in that he has stated in a very misleading fashion, Your Lordship. So, and as for this report from the doctor, Your
this
Lordship,
particular part so that I can give my clarification.
yes, I'll do
Which
one.
one?
Just a minute.
Yeah.
Lordship, as for medical reports, Lordship, in majority of the criminal matters, the doctor in connivance with the patient, Lordship, this kind of opinions are passed usually, and this.
See,
Yes.
when was this? You see, you're referring to Annexure 2.
Yes. Page
This
50.
was a document of. You see, that is why Mr. Sierra,
Yes,
should
yes,
have given a
Lordship.
clear copy.
I-
If I read it properly, the last portion of that page 18.
Yes, Lordship.
It says send date 18/10/2020 2024.
Let me clarify on that, Your Lordship.
So on this date, then the matter is in process.
The disbursement is in process. Sanctioned, approved. No doubt about that. Which one you're talking about, Your Lordship? Again, I'm
Yes,
sorry.
Send it. Just one. 7/2.
7/2/25. Send date. Department Health and Family Welfare. Office Health and Family Welfare Department. In process. It is in process. Sanction approved. Now this date, if you see, it's on the last update as seen from this particular status report is on the 7th of February. The family had gone on the 11th of February, wherein she, on which
7th
day this
February,
was made?
now we are on 24th.
24. And as on date as well.
As on 24th, matter
No.
should have progressed.
Yes,
No, it has not
But
reached.
where is the latest?
So this is the latest which we got. And Your Lordship.
When did you get this?
11th of February.
On 11th
11th of February.
Then from 11th February till today, what happened?
No, it has not reached, Your Lordship. And we keep going after 2-3 days. But this we are specifically asked for the court. It has not reached. Nonetheless, even if Vellore episode is actually taken out of the picture, the other factors are there, Your Honor, for which this bail can be considered.
A period of 150 days has been granted, Your Lordship, by Your Lordships, and yet nothing has been done. They have not taken any steps,
We
Your
went to the
Lordships.
most premier institutes within the system.
It's
What
not
else
their
can I
fault.
do?
If the department takes its time.
Besides, the department is
They
that
should
is
have
one
confirmed,
point.
Your Lordship, before coming for asking for
Lordship,
bail.
the
They should have-
department, it's fine. I understand that. The last status report is of 11th of February, as per my knowledge. And as on date, also when I called the petitioners, he said the disbursement has not reached. In any case whatsoever, the psychological condition cannot be brushed aside. I remember us having this argument, a heated argument on the last day, wherein the court has also advised me to go to other institutes. The other institutes also are addressing the same thing. How long do we keep him inside for? The state must actually take note of the plight of the accused, and at least in this situation.
This is not a serious case, Lordship. It's not a serious.
I've heard the parties.
I would, if I was to say, I would actually not object so much. Right. I'll take. Good to you.
Pass is yours.
I don't know.
I want chief him. I'm ready. Call me to you.
Item number 6.
This matter, I said we will take it up in the second half.
Yes, Your Lordship.
We will. Unless I would case now. Oh. I see. Thursday. Later on Thursday. You inform your. Yeah. your senior?
Since we have many matters this weekend, let this matter come up next week, Your Lordship.
Fine. You inform the parties. No?
Okay, Your Lordship.
I don't to be more. On pre-made parties, this is matter of the 1 week.
Much obliged, Your Lordship.
Please, Lordship, with your kind indulgence, Lordship, I beg to mention one matter for listing tomorrow, Lordship. In fact, the matter was listed before court number 2. It has been recused, Lordship. Some urgency in the matter. It's regarding check gate, Lordship. For tomorrow, Lordship. Hello, Lordship.
Thôi em.